Sir, I would like to state for the record, I am not the all caps name on the paper. I am the living man. I am a foreign national. I am here by special appearance only, held against my will, under duress, in false.
County Jail, are you Anthony Dubas?
Sir, I would like to state for the record and correct that I am not the all caps name on the paper. I am the proper case trade name, sole living heir, beneficiary, and executor of that named trust. I am the living man. I am a foreign national, and
You're a foreign national?
I'm a foreign national. I'm an American national. I am here by special appearance only, held against my will, under duress, in false imprisonment, and under false arrest.
Very good. This is State of Kansas versus Anthony Edward Dubas, case number 23 TR 2777. The state appears by Jared Regier. Mr. Dubas appears from the custody of the Butler County Jail. All parties are appearing by Zoom. Mr. Dubas.
Buckle up, because this courtroom session is about to get unbelievably chaotic. Meet Anthony Dubas, a self-proclaimed sovereign citizen who believes a few Google searches and made-up legal jargon can outsmart an actual judge. From the moment a hearing begins, Anthony rejects his own name, claims he's a foreign national, and says he's being held against his will. Sounds wild, right? Well, this is just the beginning. Sovereign citizens like Anthony often argue they're not bound by U.S. law, using pseudo-legal phrases like, "I did not stand under these charges," or "I'm the living..."
You're here for a first appearance. Do you have a copy of your charges?
I am, my honor, Mr. Crum. I am here by special appearance under duress.
You've already been through that. I'm going to read your charges to you. In count one, it alleges that on August 17th, 2023, you did then and there unlawfully operate a motor vehicle on a highway of this state without having a valid driver's license. That is no valid driver's license, a Class B non-person misdemeanor. That carries a maximum penalty of 6 months in jail and up to a $1,000 fine. Count two alleges that on August 17th, 2023, you're operating a motor vehicle, a 2003 Honda Accord, upon a highway or this state, East Fox Trail Street, Andover, Butler County, Kansas, while your vehicle was not registered. That's failed to register a vehicle. That's an unclassified non-person misdemeanor. That carries a maximum penalty of 30 days in jail and up to a $500 fine. Count three alleges you operated a motor vehicle on August 17th, 2023 in Butler County, Kansas, without having valid insurance. That's no proof of insurance, a Class B non-person misdemeanor. Do you understand your charges, Mr. Dubas?
No, I do not stand under these charges, and I would like to make it clear that I was not operating a motor vehicle. I was operating my private conveyance, not for hire, not for commercial use, not to transport passengers or products for hire.
Here's where the tension really starts simmering. As a judge politely reads Anthony's charges, driving without a license, no registration, and no insurance, Anthony interrupts again, refusing to even acknowledge them. He says he doesn't stand under the charges, as if clever wordplay is a legal shield. What's fascinating here is the psychological pattern. Many sovereign citizens believe courts are fictional corporate entities, and that using the right language frees them from jurisdiction. But in reality, judges have seen this hundreds of times, and it never works.
And if I was allowed to have my folder with black text case law in it to be brought here with me, as I asked Mr. Deputy Khalid Baraka, and he refused, I would be able to prove to you with black text case law what the Supreme Court rulings from multiple different cases have stated about the definition of a driver, an operator, a motor vehicle, an automobile, what a conveyance is, and their decisions, aka, my bad, the Supreme Court's decisions.
All right, Mr. Dubus, I'm going to stop you
not
there.
requiring-
I'm going to enter a not guilty plea for you. And we're going to set this over. If you want to present this stuff, you can present it to Judge Webster, who's going to be assigned to your case. Are you going to be able to hire an attorney?
I'm sui juris, I'm not a ward of the state.
Okay, then you can hire your own attorney. I'm going to set this for November 13th, 2023 at 9 o'clock in the morning. Mr. Regier.
Here it is, the famous binder moment. Anthony insists that if only he had his black text case law folder, he could prove his innocence. He claims the Supreme Court has already decided that words like driver or operator don't mean what we think they mean. This is classic sovereign citizen theater, citing vague Supreme Court rulings that don't exist or are wildly misinterpreted. The judge, clearly sensing the futility, shuts it down immediately. Notice his tone, measured but firm. He enters a not guilty plea for Anthony and moves things along.
Do you have a recommendation for bond?
Your Honor, 2,500 cash or surety with all standard conditions. Also, in reviewing the affidavit, it would appear that when this is alleged that when the defendant was questioned by the deputy, he refused to provide a valid address or any further information. That's quoting directly from the affidavit. I'm not sure if the court wants to make any special orders along those lines or not.
I object. I provided a valid address. It's just a non-residential address, or a residential address that is non-domestic. And he refused to accept my proper address or my mailing address.
Well, I'm going to set a bond in the amount of $2,500 cash or surety. You'll need to provide a valid physical address to a bondsman if you wish to make bond, Mr. Dubus. All right, is there anything else, Mr. Regier, on this case?
No, but from the state's perspective, Your Honor.
All right, we'll be in recess. Mr. Dubus, you are excused.
Hold on, is it an OR bond or?
No, it's a cash or surety bond.
Okay, so I need a cosigner.
You can put up $2,500 in cash, or you can make arrangements with a bondsman.
Okay, thank you.
You can practically feel the courtroom energy shift here. Anthony's obsession with semantics, non-domestic address, special appearance only, private conveyance, turns a hearing into a surreal back and forth. The judge maintains professionalism, but there's a subtle tone that says, we've reached the end of logic. And yet, this is what makes courtroom moments like this go viral. Not just the absurdity, but the contrast between authority and delusion. The judge doesn't mock him. He doesn't yell. He simply applies the law, point by point, until Anthony runs out of steam. That calm, procedural response is the ultimate rebuttal to nonsense.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. Mr. Cornelius,
Yes, ma'am.
counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cornelius, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes,
State, are you proceeding on the indictment as presented?
as judge, we're going with the lesser included offense robbery.
Any objection?
No.
Showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to accept your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Did you understand by signing?
Here's the kicker. When it's time to set bond, the prosecutor recommends $2,500 cash, totally standard for these charges. But Anthony, he objects again, saying his non-domestic address should have been accepted. Imagine arguing your made-up address is legally valid. The judge doesn't even flinch. He explains that if Anthony wants to make bond, he needs to provide a real physical address. It's a small but powerful moment, a reminder that the legal system is built on reality, not imagination. And yet, Anthony still doesn't seem to grasp that. It's like arguing gravity doesn't apply because you don't consent to it.
That you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and no contact with Jose Aguilar. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officer exhibit 1 and all offense. No objection.
All right. And state, have you been in contact with the complainant?
So we have been in contact with the complainant, Your Honor. There were other co-defendants in this case. One of them also did have a charge reduced to robbery and was given to her.
All right, thank you. Oh, you may be excused to continue to confer. Mr. Cornelius, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge, we're waiting to get back.
All right. Anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right. So everyone, please whisper in the box. We're on the record.
Break down Anthony's charges again. No license, no registration, no insurance. All basic enforceable laws. But sovereign citizens try to dodge accountability by redefining terms. To them, a car becomes a private conveyance, and driving becomes traveling. The idea is that if you reframe the vocabulary, you can reframe the law. But here's the truth. This strategy has never worked in any legitimate U.S. court. Every single time, judges reaffirm jurisdiction and move forward. What we're seeing here is more than arrogance. It's denial dressed up as legal philosophy.
My client had court in the 22nd District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now, 922N. 18 USC 922N. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered deferred adjudication from the state. He's accepted it pursuant to the court's approval. As part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he would be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right, are you employed?
Yes, ma'am.
What do you do?
Packing, moving, Apple moving service.
Okay. All right, this is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose.
At this point, the judge's patience deserves an award. He's heard the same phrases, the same pseudo-legal buzzwords, yet he stays steady. No sarcasm, no anger, just procedure. By entering a not guilty plea, assigning the next hearing, and setting bond, the judge reclaims control of the courtroom, redefining words. It's about process, facts, and order. Watching this unfold feels like a slow-motion chess match, and the judge quietly checkmates Anthony without breaking a sweat.
Reporting by Zoom or in person, regular UAs, 200 hours of community service restitution. There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits, 1 time per month for 3 months. And probation, if you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with Aubrey Reed, Aubreyreed, Charlie James Ray Perkins, Amari, Emari, Lafel, Lafel, Freeman, Freeman. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else he needs? Yes. All right, is there anything else you need from the court to have Black excellence in your life?
Oh, ma'am.
Judge, maybe run this concurrent with this federal cause number. I can give you that cause number.
All right, concurrent with what's the number?
SA:22-CR-294.
All right, the court will run it concurrent.
Thank you, Judge.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
Oh, ma'am.
All right, we can go off the record. Here's the thing. From here on out, in this court, whatever you do in your life while you're on probation, you need to ask yourself 2 questions. 1, is what I'm doing something that could potentially result in me being revoked and sentenced to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
Yes, ma'am.
All right, good luck to you.
So what did we just witness? A textbook case of sovereign citizen logic colliding with actual law and losing. Anthony tried to outsmart the system using buzzwords and fictional interpretations, but the judge's calm, professional approach dismantled every claim with patience and precision. This video perfectly highlights why courtroom discipline matters. Judges don't need to shout to win. They just need to uphold the law. And honestly, this judge's restraint was nothing short of impressive.